I'm going to be talking about licensing and packaging and labeling, and then I'll turn it over to Gerald, who's going to talk about some more specific offenses and enforcement under the new cannabis regime. So first, it's important to familiarize ourselves with the governing legislation. So there's three main pieces that you should familiarize yourselves with. First, there's the Federal Cannabis Act. There's the federal regulations to the Cannabis Act, and then there's third, for our purposes in Ontario, the very not helpfully named Cannabis Act, which is just the Ontario form of the federal cannabis legislation. If you're wondering what this all looks like, this is it. So if you're looking for some fun bedtime reading, I can hook you up. And this is double-sided, so it's pretty exhaustive. So I'm going to talk about who can be a producer of cannabis in Canada. So first, in Ontario, you must be 19. This is an area where you might see a little bit of difference or variance from province to province. And you need a Health Canada license. And you need a license that's going to be specific to exactly what you want to do. So there's different licenses depending on whether you're a large-scale grower, a small-scale grower, a starting material grower. So if you want to have a nursery, for example, with starter plants or with seeds, you need a specific license for that. You need a specific license for medical cannabis. You can also have more than one license, and you can apply to have certain licenses amended. So that means if you were a licensed producer or LP under the previous medical regime, you can actually apply to have that license amended to be a different license under the Cannabis Act. And to get a Health Canada license, you need something called security clearance. So when the Cannabis Act was originally tabled, there was a lot of discussion about whether people who had criminal records were going to be allowed to produce or manufacture cannabis. So the answer is maybe. So there's not a strict prohibition if you have a criminal record, but it's considered in granting security clearance, which is essentially the government consideration of whether you as a manufacturer will pose a risk to public health or safety, or whether there's a prospect that, or risk that cannabis will be diverted to the black market. So the Cannabis Act allows the minister to conduct criminal record checks at any time, so it doesn't stop once you actually get the security clearance. After you have security clearance and after you have a license, the government can still check up on you. In fact, there's actually an ongoing reporting obligation to the government. So once you do have a license, if you're subsequently charged with an offense or convicted of an offense, there's an ongoing reporting obligation if you're the holder of a license. The next thing you need, aside from the Health Canada license, is you actually need an Excise Act license. This is essentially a tax thing. You need a license to affix specific stamps to packages that essentially say that you have produced the product legally in accordance with regulations and that you've paid all applicable taxes and duties. So I'm going to chat a little bit about some of the packaging and labeling requirements. This makes up a very large portion of the Cannabis Act and the regulations. So the rules are extremely strict, and so I've just pulled out a few of the main ones that I think will be most interesting and most relevant for you guys. So first, there's a very broad prohibition to sell cannabis in a package or with a label that could be appealing to young people. That sets out a testimonial or endorsement. So my name's Lindsay, I really enjoyed this cannabis product, this is how it changed my life. Nothing like that. Nothing that depicts a person, character, or animal, either real or fictional. So our friend Ted, unfortunately, is off the table. Nothing that associates cannabis with glamour, recreation, or excitement. So that's similar to some of the stuff that we see with tobacco. No, like, glamorous people smoking marijuana, unfortunately. And nothing that contains false, misleading, or deceptive information. The container cannot contain more than 30 grams of dried cannabis. It has to be child resistant. The packaging has to be the most boring packaging you can possibly think of. It has to be one single uniform color. It has to be matte. It can't have the luster of metal. It can't be fluorescent. But fortunately, the interior and exterior can be different colors, so you can get creative there. Okay, so here's where it starts to get complicated. There's a very broad prohibition on using terms, expressions, logos, symbols, or illustrations under the Act and the regulations. But the regulations carve out a specific exception for producers to put both a brand name and a brand element on the package. So for brand names, on the label, there's a bunch of enumerated requirements just for that. So for example, it can't be bigger in size than the health warning that's required to be on the label. And there's also the normal slew of prohibitions that we just talked about. So the brand name can't have the luster of metal, and it can't be fluorescent, and it has to be, it has to meet all the other requirements. And the brand element, you're allowed to have one sort of brand-related depiction on the product, but again, it has to meet the requirements we just discussed, and importantly, it can't look like the standardized cannabis symbol, and that's actually a defined term under the legislation. It looks like this. What doesn't look like the standardized cannabis symbol, I think, remains to be seen. I think it's going to be a big challenge for producers for sure. Whoops. Okay, I'll leave it there, but some final labeling requirements. All the labels have to include the contact information of the producer, the class of the cannabis, the health warning message, THC content, and food allergens, and because we're in Canada, it has to be in English and French. If all of this sounds incredibly strict and onerous on producers, we agree with you. In our view, the packaging and labeling restrictions are constitutionally suspect, and this is an area where we're likely going to see a lot of litigation in the future. Commercial advertising is protected as a form of freedom of expression under Section 2B of the Charter, and we think that this area is possibly ripe for a charter challenge in court. I'll turn it over to Joe.
So growing up as a criminal defense lawyer, I'm always concerned with what happens when my clients break the rules and do not comply, and so I'm just going to talk for a few minutes about the sanctions and how they're enforced. Marijuana, prior to this change in the legislation, was governed by the Controlled Drugs and Substances Act. That was a criminal statute, right? It was a Schedule II substance to the CDSA. No longer, now it's governed by its own statute, the Cannabis Act, but that doesn't mean that there are no more criminal elements. The Cannabis Act contains criminal sanctions as well as purely regulatory sanctions. And so this can be a bit perilous for those who are regulated entities in the field. For example, the provisions that are, you'll see Division 1 there up on the slide, that's what deals with criminal activities in the statute. And there are a number of sections under Division 1. The ones most pertinent for regulated entities will be Section 9, governing distribution, Section 10, governing selling, Section 12, governing production, and Section 13, governing possession for the purpose. And a number of these provisions contain a general provision saying you can't do the regulated act unless you have the proper authorization to do so. And if you don't have the proper authorization to do so, it can be a criminal offense. So it's an interesting dynamic where you've got a regulated sphere, but if you step outside of the regulated sphere, it's not just regulatory sanctions that you can be subject to, but you can be back into the criminal law world, depending on the rule that you're not complying with. Certainly doing any of the prescribed acts without proper authorization can subject an individual or an organization to criminal liability. It's also not just federal legislation that regulated entities have to be aware of when it comes to the possibility of criminal exposure. It's also provincial legislation. You saw on the first slide that Lindsay showed you that there is a provincial statute by the same name, the Cannabis Act. Well, under the federal statute, a couple of provisions you'll see references to illicit cannabis. It's an offense to distribute under Section 9 illicit cannabis. It's an offense to possess for the purposes of distribution under Section 13 illicit cannabis. What's illicit cannabis? Well, that's defined in the federal statute under Section 2 to mean cannabis sold, produced, or distributed by a person prohibited from doing so under either the federal statute or any provincial act. And so again, if you run afoul of the provincial legislation, there is potentially criminal exposure under the Federal Cannabis Act. And the sanctions as all criminal sanctions, can be quite severe. There can be significant fines for organizations and imprisonment for individuals. Now, having said that, and having that's scared anyone in the room who may be thinking about being a regulated entity, not all of the prohibitions in the Cannabis Act will expose individuals or organizations to criminal liability. You saw earlier there was Division 1 of the statute governing criminal activities. There's Division 2 titled Other Prohibitions, and it's under this section that you'll find some of the rules and restrictions that Lindsay was talking about earlier, namely packaging rules and restrictions governing packaging, labeling, promotion, etc. So given that they're situated under a different portion of the statute, arguably the criminal sanctions don't apply to these prohibitions. That doesn't mean that there aren't still significant sanctions that could apply. For these prohibitions, indeed for any prohibition under the statute, the Health Canada or the regulating body can issue administrative monetary penalties. And if you're an organization that is concerned mainly about the bottom line, the penalties can be quite severe, up to $1 million for infractions under the Cannabis Act. Now, of course, administrative monetary penalties, the Supreme Court of Canada has held, do not engage Section 11 of the Charter. That's a provision of the Charter that guarantees you sort of the whole panoply of fair trial rights, full disclosure, presumption of innocence, etc. And so you don't get the gold standard of procedural protections if you're subject to one of these penalties. You do, however, you are still, however, entitled to procedural fairness, and the statute lays out a regime for that, proper notice of what the alleged violation is, and an opportunity to seek review. How are these offenses and prohibitions going to be detected? How are they going to be enforced? Well, the governing body is Health Canada, which will work in collaboration with other federal agencies, the CBSA, the CRA, the CFIA, every other alphabet acronym you can think of at the federal level. And they will have mainly two avenues by which to enforce these rules and regulations. And I'll just touch on them briefly in the interest of time. The first are Health Canada will have very broad inspection powers, similar to that which you have under a number of other regulatory statutes for those in the room who practice in the regulatory sphere. For example, under the Food and Drugs Act, when the CFIA has broad inspection powers to go into food processing plants, for example, and visually inspect, collect and review documents, take samples, etc. Well, the same is true under the Cannabis Act. Health Canada inspectors will have fairly broad inspection powers to go into any place where they have reasonable grounds to believe there is a regulated activity under the statute taking place. And once inside, and they don't need these are inspection powers, so they don't need a warrant to go in. They can just go in. If you've done regulatory work under other areas, there are some areas. Again, I come back to the Food and Drugs Act example, where the regulator has a parking spot sometimes on site at the premises of a food processing plant, for example, because that's how frequently they can be in these places. And so we'll see whether the same is true for any of the licensed producers. But certainly inspectors can go in, they can visually examine the facilities, inventories, equipment, packaging, labeling. They can collect and review documents and records, take samples for lab analysis, and they can also seize cannabis where they believe on reasonable grounds that the cannabis relates to a contravention of the statute. There is also a search and seizure provision in the Cannabis Act. Now, this applies not to Health Canada inspectors, but to peace officers. Where a peace officer has reasonable grounds to believe that, again, there's cannabis in respect of which the act has been contravened, there are containers or concealers storing such cannabis, there is other offense-related property, or there's evidence of a Cannabis Act offense or an offense under the criminal code like money laundering or proceeds of crime, where they've got reasonable grounds to believe that one of these exists, they can get a search warrant to go into the place of business of an entity regulated under the Cannabis Act to seize the cannabis and evidence. And so a logical question that follows from this is, well, if they have broad inspection powers under a separate part of the statute, why would anyone ever go get a warrant first before going into a regulated place? And the answer is because the inspection powers are expressly limited in terms of the purpose for which they can be exercised. The inspection powers are limited to a purpose related to verifying compliance or preventing non-compliance. In other words, a regulatory purpose as opposed to predominantly a penal purpose where you're investigating simply to gather evidence of an offense. And that distinction reflects a distinction that the Supreme Court of Canada has drawn. If you are a regulator and you are going into a place without a warrant simply to exercise your broad inspection powers, you can do that so long as your purpose is really regulatory. This is a distinction drawn in a case called Jarvis. But if you are going in for the predominant purpose of investigating, gathering evidence to establish an offense, in other words, if your purpose is predominantly a penal one, then you have to get a warrant, and the way that the Cannabis Act has been set up respects that distinction. Thank you so much.